Welcome to our show, Immigration Talk Show. I'm your host, Shivani Raj. Please know that Sakshi TV now has 4 immigration shows every week. On Tuesdays with Mr. Kaveti, on Wednesdays with Prashanti Reddy in English, on Thursdays with Chand Parvathaneni, and on Fridays with Banandara. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usasakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on this show is not legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need any specific legal advice, you can definitely contact the attorney directly. Mr. Chan needs no introduction, but if you need consultation, please log on to their firm, which is svblawfirm.com site. They provide with multiple information about US immigration policies and terms, which you do not have to be a lawyer to understand. So without any further delay, let's welcome Mr. Parvathaneni on our show. Mr. Parvathaneni, welcome back. I hope you're doing well.
Hello, Shivani. Thank you, and thank you everybody for joining in the show at Sakshi TV.
Yes. Mr. Parvathaneni Garu, before we get onto the topic, are there any latest immigration updates? Because we will be talking about 2024 CAP registrations, but let's just get done with the latest immigration updates first.
Sure. We have a couple of good updates, actually. So we had one update come through where they said USCIS, they came out with the criteria for the compelling EAD card. So compelling EAD card, it's a good step. It will help a lot of people to stay back in the country, even if they're losing status. So there was one announcement about USCIS encouraging people to use that feature, the compelling EAD card feature. That was one good thing. And then we also had very good news where people who are in the country, in US, they should be able to change to student status in case they're looking to change to student status. And they can do it under premium processing. So this premium processing was not available all along. And what that meant is a very complex process to change to student status. And now USCIS has made it easy, and they just came out with this announcement that will be effective from June 26th for all new F1 applications. So it'll be a lot more smoother, a lot more easier because they will be able to avail of premium processing service. And one final update is regarding H1Bs. So June 30th. So June 30th is the last date to submit CAP H1Bs. So CAP H1Bs are basically the H1B application, the lottery that happened in March. So whoever got selected in the lottery, they have time until June 30th. So June 30th is the absolute deadline for those lottery selections to be submitted. And if those cases are not submitted by June 30th, USCIS will start rejecting the cases sent afterwards. So final week, another final push. So anybody has any company has any pending H1B applications, they need to do it before June 30th.
Yes. Yes, Mr. Parvathaneni. Before that, let's also get on to the topic that we decided that we'll be talking about. So we heard that the H1B visa holders in USA can now get a new EAD card called as the compelling circumstances EAD card that you just mentioned. So can you please give some information about this new EAD, what exactly it is, and also can you let us know how does this new EAD card work?
Sure. So the compelling EAD card, so it's been there for a while, and USCIS, their announcement, they clarified on the various criteria and what needs to be done and so on. So to give a brief summary, a compelling EAD card, it's a feature where one can stay back in the country when they're losing status. So under certain circumstances, somebody is allowed to use this card, compelling EAD card, and they can stay back in the country. So there are a couple of criteria. The main criteria is that somebody should have an I-140 approval. So I-140 is basically the petition where the company, their employer, files for a green card. So if the I-140 is approved for somebody and they're in the country on H1B status or L1 status and they qualify, they're in the country in a legal status, they can use this compelling EAD card. And what compelling EAD card does is they don't really get a specific status, but what they get is they're able to stay back in the country and they don't accrue illegal or unauthorized unlawful presence in the country. So What that means is if somebody has lost their job and they need to stay back in the country even after the grace period, that is basically after 60 days. So they can probably use this compelling EAD card if they qualify. They meet the test, the subjective test that is relevant based on their facts. USCIS will issue them this compelling EAD card and they can stay back in the country. And in the future, however, if they need to get back into a valid H1B status, they cannot get back into valid H1B status by itself because all this compelling EAD card does is they can stay back in the country because of some various reasons. And eventually they would have to go back out, they would have to go out of the country and re-enter under a valid visa. So it's at least a temporary short gap measure as long as those compelling circumstances exist for that particular person.
Yes. So what exact circumstances are we talking about? What circumstances can be included to get this EAD card?
So compelling circumstances mean some kind of circumstances where that person is seriously harmed, maybe serious financial harm or something of that sort. And to give a typical example, if, say, for example, somebody, they have a dispute with their employer, or somebody is a whistleblower, and because of that, they are not able to maintain their H1B status. They're probably losing their job, or they're not able to do their job. Or, for example, say somebody has some serious medical condition, maybe somebody in their family, they have to provide care. And what that means is because they have to provide some medical care, they're not able to do their job and they're not able to maintain their H1B status. So when you have these kind of serious circumstances where somebody is seriously harmed, either medical reasons, financial reasons, either because somebody is running into a dispute with their employer or various reasons, the harm is serious. They should be able to apply for this compelling EAD card. And what USCIS is saying is everybody's case is different. Because everybody's case is different, if somebody has a case where they are facing some serious harm, whether it's financial or some bodily or some medical issue, something of that sort, reach out to them and request for this compelling EAD card. And that would let them stay back in the country. So all it does is, hey, if somebody's got a serious medical problem, they need to stay back in the country because they have ties to the country, but they cannot continue their status, but they cannot just leave the country because they have very close ties to the country, either a house or either they have children who are attending school, so they just can't leave the country all of a sudden. When you have those kind of serious circumstances, this is a good feature to use.
Yes. So, can one stay back in the country when when the compelling EAD card is still in process? And also, what are the typical timelines for this?
So, people can expect almost close to 6 months to get adjudication on this compelling EAD card. And that being said, if they have some reasons to qualify for an expedite request, because USCIS has a policy under which they can expedite certain requests. So if they qualify under expedite category, they can probably reach out to USCIS to expedite the request. But if not, they're probably looking at about 6 months. And while the compelling EAD card is in process, as long as this application is not a frivolous application, and there is some kind of merit to the application, as long as it is pending, they can stay back in the country. So tomorrow, if it takes a longer time, as long as it is currently pending, they're good to stay back in the country. However, one key thing to note is at the time of filing for this compelling EAD card, one has to be in the country in a legal status. So assuming somebody files for this compelling EAD card while they are maintaining their status, they're good to stay back as long as this application is in process.
Yes. Mr. Parvathaneni, we're also hearing that these delays in the visas and everything, people can actually file a lawsuit. So can we talk about this specific lawsuit, and also what kind of lawsuits can be filed, for these kind of green card or visa delays? Because I'm sure it's a huge problem for people who are actually staying there because their status is still unknown and they don't know, and also, I'm sure it's a very big huge problem. What kind of lawsuits can be taken to protect these kind of issues?
So So there is something called writ of mandamus. So this is a kind of a lawsuit which you file against the government, actually the government agency. And the purpose of this lawsuit is you're suing the government and you're asking them to expedite a certain request. And when is it used? So typically there are a lot of circumstances. So somebody has a pending green card application, or somebody has a pending visa application at the consulate, a H1B visa application at the consulate. And if the agency is taking a very long time, and when I say a very long time, more than the usual normal time that it is normally taking for such cases. So if there is a, a lot of undue delay for somebody's case, this is a good ammunition to use. So there is a process where you can sue the government agency and you can compel them, you can force them to answer to the lawsuit. And this is typically known as the writ of mandamus. So basically, it is mainly used for, from in my experience, we typically use it for green card delays because somebody's date is current and USCIS, they're not adjudicating the 485 within their timelines, and the timelines are published. So based on where the application is, which service center or wherever that application is, USCIS typically publishes the timeline. And if the timelines are exceeded drastically and there is no response from USCIS, and somebody went ahead and exhausted all their options, and when I say options, contact USCIS, or if it is a consular visa issue, contact the consulate and try for resolution. And the key thing to note is make sure you are waiting until the normal processing time is crossed. And if the normal processing time is crossed, you are trying to contact them and you are not getting any response. This is like the last resort mechanism. So at that point of time, you file a lawsuit. You file a lawsuit against the government agency, and you are forcing them to answer you. It does work, but the only thing to keep in mind is it's an expensive process. So do make sure that it is used only in genuine cases. And when I say genuine cases, what I mean is there is really a very, very large amount of delay, and one did exhaust all their options. That is the only time pretty much I would suggest go ahead and file this writ of mandamus against the government.
Yes. And also, Mr. Parvathaneni, we are hearing that one can convert their residence visa to a student visa under premium processing. Is that true? And if yes, what's the good process like?
So we get a lot of queries from a lot of people. They're in the country, they're in US, and they decide to get into student status, the F1 status. It was allowed even previously. However, the process is they file for an I-539. So they have to. The first thing is they have to get a admission in the college. So once they get an admission in the college, they get an I-20. And using the I-20, they have two options. One, they can go out of the country, get F1 visa stamp, and come back. And a lot of times, because somebody is already in US, what they want to do is they want to just convert to student status without getting a visa. It was possible even in the past, but it took a very long time. It took almost 6 to 8 months to get the conversion done. And during that time, somebody had to stay in the country and do nothing. And luckily, starting from this month, June 2023, USCIS has started premium processing. And what that means is somebody can apply for change of status from, say, for example, tourist visa to F1 visa or any other legal status. For example, some people who are on H4, they want to convert to F1. So people can convert to F1, the student status. And the new rule is they can use premium processing. And what that means is they can get it done very, very quickly. So it is a good thing. It is an expensive process. Premium processing is expensive. But at least now people have a means. People have a means where they can convert to student status while they're in the country, and they can do it very quickly. So this premium processing is something that just got announced, and more than likely we are already seeing a lot of queries on this, and I think a lot of people will use this premium processing to convert to F1 status if their desire is to study and then leave the country after the studies are completed.
Yes. Yes. So, Mr. Parvathaneni, because of the recession or whatever circumstances where a lot of people who lost their H1B jobs, they filed for their B1 or B2 tourist visa. So now we're also hearing that the USCIS is prioritizing or approving these kind of cases. Is it actually true? And what is your point of view on this?
So whenever somebody on H1B, they lose their job, they typically have 60 days to convert to a different status or find a new job. And normally what used to happen is people used to find a job within 60 days easily. And that's what happened in the last couple of years. However, recently we are hearing about a lot of tech layoffs, and some people are struggling to find a job within their mandatory grace period, which is a 60-day grace period. And but again, USCIS permits somebody to convert to B1, B2 status if they just need to stay back in the country temporarily and wind up their business. So what that means is they are crossing their 60 days. They lost their job. They're crossing their 60 days, but they have a need to stay back in the country because they either have a home there, they have to sell, and they have a few things to take care of. So what people do is they apply for the B1 visa, the tourist visa. Uh, the problem is while they are in the country on that visa, sometimes they find a job, they find a new job. And when they find a new job, the process is that new company has to apply for H1 and they cannot work on the receipt because they have converted to B1. Until they get an approval, they cannot work on H1. They cannot work on a receipt in those cases. And what that meant is now because USCIS has to approve that case and they have to wait, it was a complex process. They have to probably go for consular processing or they have to wait until their B1, B2 is processed before their H1B gets approved. So that was what was happening in the past. And lately, what we are seeing is USCIS, they have been prioritizing such cases where they have a pending B1, a pending tourist visa application for those H1B people. So USCIS is indeed prioritizing those cases. And what they're doing is they're simultaneously adjudicating the B1 case. They're also simultaneously adjudicating the H1B case. Previously, they used to say, wait until your B1 case is approved. Now what they're doing is they're doing it together. So they're saving time. And luckily, that is enabling people to very quickly get back into H1B status in case they have a new job offer.
Yes. And let's talk about second lottery, Mr. Parvathaneni. Now that the day is already June 30th now, and it's the last day for the filing, do you think there's a possibility of second lottery this year?
So this year, I think, in my opinion, more than likely we will see a second lottery, and there are a couple of reasons for that. So last year we had only one selection, so there was no second lottery. But the years prior to that, we always had a second lottery. So the 2 years prior to that, and last year what happened is USCIS they selected more numbers, and the market was very good, the tech market. So we definitely had more people file, and we did not have a second lottery. This year, I think we are seeing two main issues. One, we are seeing a tech industry slowdown, but the tech industry is still strong, but definitely we have seen a lot of layoffs this year. So definitely there is some kind of a slowness. And then the second and the most important thing is multiple registrations. So there was a lot of fraud, misrepresentations that happened as regards to the multiple filings. And USCIS in the month of April, they came out with the notification and they pointed out, they gave numbers to prove or at least to show that they have a valid reason to believe that there is fraud happening in H1B lottery, in H1B registrations. And the reason for that is they showed statistics from last year, they showed statistics from this year, where they are seeing numerous filings, numerous beneficiaries with multiple filings. And so what USA said is they suspect fraud, and they gave a very big warning. And they said if they find people are committing fraud, they will refer them to criminal prosecution. And criminal prosecution means, in layman's words, arrests. So if there is a criminal prosecution, and if there is a case for the enforcement agencies, they will go and arrest those people who committed that criminal offense. And when USCIS came out with this notification, I think people took a step back, and definitely people started looking at very closely at their data. What kind of filings happened? What kind of filings did the employee do? And not every multiple registration is an issue. Not every multiple registration is prohibited. There can be two independent companies who have completely bona fide and independent jobs. Those multiple cases are completely legitimate. However, USCIS is talking about collusion. They're talking about collusion where people didn't really have a bona fide job offer. They just registered in the lottery. And what USCIS is saying is people are doing this just to increase the chances in the lottery. So those kind of colluded cases where somebody is trying to cheat the lottery just to increase the chances in the lottery, that is what is not allowed. And they're talking about those cases. And at least because the good thing is because of this USCIS notification, people are taking a step back. And we are warning various employers, various petitioners. If you think there is at least some kind of a direct collusion or even an indirect collusion for whatever reason, make sure you don't file the case. Make sure you don't get the benefit, because one is not allowed to get a benefit when there is fraud or misrepresentation. And I think at least people who are realizing their mistake, they are taking a step back. And because of this reason, we do expect a lot of filings not to be done. A lot of people who have been a part of collusion, who have colluded and done the registrations. We are hoping that those petitioners do not file the cases. And because of this reason, we do think that a lot of people will not file. And definitely that will enable USCIS to open up more selections in the second round. And June 30th is when the USCIS will stop accepting the new cases. And after June 30th, they will not accept any more cases from the first lottery. So July is when USCIS will be able to take a look at their caseload. They will be able to see how many people have actually filed once all the receipting process is completed. And that will give them an idea on how many cases are, how many slots are open. More than likely, end of July or August, early August, we can expect some kind of a notification from USCIS. I'm hoping that they will release some statistics, and more than likely, we can expect a second lottery this year because of at least what I'm seeing in terms of the filings that are going on this year.
Yes. So Parvathaneni, we're also hearing that some of the companies are charging the employees for filing H1B. Is it even legal, first of all, for this to happen?
So it is highly illegal for a company, any company, to charge their employees a H1B fee. So a company cannot charge anybody a H1B fee, and there are very, very strict rules on this matter. And unfortunately, we keep hearing this all the time. We keep hearing that the companies are charging the employees. If a company is charging an employee for the H1B fees, it is criminal. So we urge companies not to charge any employees any H1B fees. And at the same time, the employee should understand one thing: employees should not help in committing fraud. And what that means is the employees should be aware that they cannot pay somebody to file their H1B. So a company should not charge anybody. At the same time, the employee also should not pay the company. And if a company is asking an employee to bear the expenses of the H1B, something is wrong. The employee should stay away from such companies, because if USCIS finds it out or the consulate finds it out, there will be repercussions. And what we are seeing is, we are seeing this question routinely asked at the visa interviews. Very, very common question. At the visa interviews, you can expect this question asked by the consular officer: who has paid your H1B fees? It's a very common question. And one cannot lie to the USCIS officer. Any lies to a USCIS officer or any government officer for that matter is perjury. It will have serious criminal implications. So we are seeing this question repeatedly being asked at the consular interviews: who has paid the H1B fees? And also the site visits. So for the H1B petitions, so there is something called FDNS. So FDNS is a process where a USCIS officer can do a site visit and come to the place of employment. And during these site visits, we are routinely seeing the USCIS officers asking both the employer as well as the employee on who has paid the H1B fees. Okay, so USCIS already has a mechanism in place to find out if the employers are charging their employees anything to file their H1Bs. So what I want everybody to understand is, the company should not charge anybody for the H1B filing fees. The company should bear those H1B expenses. There are strict rules on this matter. So a company should never charge, and the employee should never pay for the H1B filing fees.
Yes. And also, Mr. Parvathaneni, do you see multiple registration notices being issued by the USCIS for the 2024 CAP filings? And if so, what kind of issues are you personally seeing?
So, so all we are seeing so far is either approvals, receipts, or very minor RFEs for the 2024 cap cases. We've seen a lot of approvals, and we're not seeing any rules change from last year. So, the same kind of rules that were applied in last year's filings, the same rules are being applied this year by USCIS. So, in terms of adjudication process, nothing has changed. I have not seen any noids or noires for the 2024 cap filings. However, we are seeing a lot of notices for the 2023 cap issues where there is a multiple registration issue. And what we are typically seeing is if there are a lot of overlapping registrations between two companies, one can definitely expect USCIS to raise that matter because too many overlapping registrations is not coincidence. And definitely that what that would mean is if two companies have too many overlapping registrations, you can definitely expect USCIS to raise that issue. Maybe they'll not raise it right away, but in the future they can come back and raise that issue. So what that means is, yes, we have not seen anything raised yet for the 2024 cap, but that doesn't mean anything. In the next couple of months, if there is fraud and USCIS has a lot of data, they can raise that issue. They can issue a notice of intent to revoke or a notice of intent to deny in the future. And the minute they see a lot of overlapping registrations, what will happen is USCIS is going to dig more. And do you have common ownership? Are the companies related by familial relationship? The same family members owning the companies? Are they having the same registered agents? Are they having the same attorneys, same law firm filing for their cases? Because it all shows that these companies knew each other and they're working together. So anything that shows the companies are working together, the companies knew each other, is going to be an issue. So, and that is how USCIS will find out if there is overlap, there is multiple registration or not. Any kind of commonality, any kind of reason that the companies give, they'll be able to find out because they have a lot of data and they have very good computer systems. So if they find collusion in their systems, they will definitely raise that issue, and they always will give you a chance to respond back. What that means is because sometimes they might not be correct. Maybe their computer flagged something, but maybe there is genuinely a reason on why that happened. So what that means is there will be a notice issued. They will give the company a chance to respond back, and that is the best chance to respond back because our suggestion is if it is indeed a wrong notice, respond back with evidence. Tell USCIS they're wrong, they're incorrect. Provide evidence. But if they're not able to fight back and if they don't have evidence, we don't want the companies to go back and tell lies to USCIS. They have to step back. The big thing to understand is any lies to USCIS is always a problem. Any lies to a government officer is always a problem. It is a criminal offense. So one should be very careful. If they get a notice, make sure you respond it accurately. Don't respond it with false information. If you respond to a notice with false information, it causes more problem. But if you have the facts right, if you have the facts to prove that you have not colluded, definitely fight back and fight back hard. So that is pretty much what I think we are seeing on the multiple registration notices in the last few months.
Yes. Mr. Parvathaneni, my next question is how long are the cases that are filed for the H1B cap currently taking? And do you see approvals for the recently filed cap cases also?
So for the cases that we filed in April and even May, we got a lot of approvals. We are seeing a lot of approvals in a very short time because again there is a reason for it. Not many people have done the filings in April. Not many people have done filings in May. June is when unfortunately everybody react because June 30th is the deadline. Everybody wake out of their sleep and everybody start reacting. So in June it is normal to see a lot of filings go at the same time. And what that means is a case in April probably will get approved quickly because USCIS probably will not have a lot of the cap cases. But in the month of June, because everybody is rushing in at the same time, USCIS will get a whole bunch of cases at the same time. So my previous experience from prior years and what I'm even seeing this year is because we are seeing a lot of people rush at the last minute, cases filed in June more than likely will take some time. But cases that are filed in April, I mean, most of them, I mean, at least what we filed on our side, we saw them adjudicated. May cases also, a lot of them are getting adjudicated. We are seeing adjudications every day, either an RFE or an approval. But cases in June, you can expect to see some time. But again, historically, most of the cases do get adjudicated before October. When I say adjudicated, at least an approval or at least an RFE before October. But you can still expect to see a lot of cases remain even after October. But the good thing is there is premium processing, and for anybody that wants premium processing, that is still available.
Yes. Thank you so much, Mr. Parvathaneni, for tuning in. I think we had such a great show. We covered so many different topics. Thank you for the viewers for also tuning in. You're watching Sakshi TV with me, Shivani Raj.
Thank you.